Ladies and gentlemen, good afternoon. It's with great pleasure and enthusiasm I extend a warm welcome to each and every one of you in a highly anticipated expert series. Today, we are honored to host a distinguished group of speakers and moderators who bring with them a wealth of knowledge and experience in their respective fields. Our expert series is a testament of our commitment to fostering intellectual exchange, promoting the sharing of insights that can drive positive change. We are privileged to have experts who have dedicated their careers in advancing their fields and contributing to the broader discourse of data security. Their presence here today reflects not only their individual achievements but also their shared dedication to pursue of excellence. Throughout the expert series, we will have the opportunity to delve into diverse range of topics, engage in thought-provoking discussions, and gain valuable perspectives from our esteemed speakers and moderators. Their expertise will undoubtedly inspire, educate, and challenge us to think beyond our conventional boundaries. To our speakers and moderators, we express our deepest gratitude for our willingness to share your knowledge, experience, and insights with us. Your presence elevates the caliber of our discussion, and we are confident that your contribution will leave a lasting impact for those in attendance. To our audience, thank you for joining this intellectual journey. We encourage active participation, thoughtful questions, and exchange of ideas to enrich our collective understanding on the DPDP Act. Without further ado, let us commence the expert series with a spirit of curiosity, collaboration, and open mindedness. May our discussion today spark new ideas, forge meaningful connections, and inspire us all to reach new heights in our respective fields. Once again, welcome to the expert series, and thank you for being a part of this enriching experience. Over to you, sir.
Yeah, thank you, Chirag, and good afternoon, everyone. As Chirag mentioned, this webinar is part of a Nathealth expert series, and we picked up very important topic for this series this time, which is about Digital Personal Data Protection Act 2023. We thought it's very, very important for all our members as well as other stakeholders to actually know about this act, get a deeper understanding, and more importantly, to know what needs to be done going forward. As we all know that new age technology, especially digital AI, machine learning, is virtually invading every part of our economy, every part of our life, and data is becoming more digital than physical. And this act will have implication for all of us as we run our organizations. So I'm happy to introduce two sets of people on the screen today. One is Dr. Anand Mehta. He's a partner, corporate and M&A from Ketan and Company. And Mr. Supratim Chakrabarti. He's also partner, data protection, cyber security, and corporate stroke M&A practice, Ketan and Company. Now, other than these two gentlemen, we also have Mr. Saurabh Gupta, who is from My IT Manager. He's a founder of this company. He's going to throw light more on solutioning side of whatever we need to do post this implementation of this act. Before I hand over to them, I thought of briefly introducing them a little more. So Anand Mehta is a partner in corporate and commercial practice group in the Mumbai office. He specializes in corporate acquisitions and mergers, India entry strategies, corporate and commercial laws, and contract laws. Anand advises clients in relation to employment, data privacy, and other corporate fraud issues, white collar crimes issues from a preventive and compliance perspective. He also helps clients conduct training sessions, supporting pre investigation of employee investigations, etc. Now, Supratim is a partner with the corporate M&A practice of Ketan and co leads data privacy and cybersecurity practice. He has advised eminent clients in relation to IT laws in India, including on data privacy and protection, intermediary liability, and cybersecurity related issues. Supratim has been providing inputs to the government on upcoming technology related laws of the country. Now, as far as Saurabh is concerned, from my IT manager, he is a founder, leads a cybersecurity consulting practice, empowering healthcare organizations, navigating uh, data protection challenges, and they have enabled clients to safeguard sensitive information through various areas. So I'll hand it over to them. Maybe first we have Ketan and company talking to us about this law, and then we will move to Saurabh, who will throw some light on solutioning side of it, and then maybe then after that we'll open it for Q&A if the time permits. So may I request Dr. Anand Mehta to take these proceedings forward. Sir, you may also want to talk a little bit about Ketan and company as well before we dive deeper into this act.
Yes, yes. First of all, thank you, uh, Nathealth, for organizing this webinar. It's a very important topic. And thank you all the members who have made it convenient to attend. Just as an introduction, I'm a corporate M&A partner in Mumbai office of Khaitan and Company. I also look after white collar crime investigation, data privacy, and employment matters. We are a full service law firm. We have presence across India. We have offices in Bombay, Delhi, Kolkata, Chennai, Bangalore, and we've also opened an office in Singapore. So we really have clients both international as well as domestic. And we are one of the largest law firms in the country. As far as Khaitan and Company is concerned. Now, coming on the topic of data privacy today, look, I think Shupratim, if you can put up that screen.
Yeah. If I can be given the sharing rights.
Hi, Manashwini. Can you share the rights with Mr. Supratim?
Yes. Shared.
Thank you. I'm just sharing my screen now. Let me
For the
know.
benefit of our audience, we are one of the oldest law firms in the country. We've turned 112 years this year on November 11th. So we are celebrating 112th year in as an organization. Yeah. So thanks. So data privacy has been a very, very important aspect of any regulation in the West. People have been very sensitive uh, in the software industry, in many other industries, where data was very, very relevant. And data is considered to be the new oil as far as the current economy is concerned. In India, it started gaining momentum when we had the Information Technology Act, which stepped up the rules, that is the SPDI rules. And it's really has gained momentum. People have become conscious and have become aware. And even in a typical normal commercial transaction or an M&A transactions, people were focusing and were trying to evaluate whether there is going to be any transgression of any data rights residing in any person. Coming to the history of the journey so far, which is very important. In August of 2017, we all know the Puttaswamy judgment came out of the Supreme Court. That really stated the whole process or set the ball in motion. It recognized privacy as a fundamental right. Then came in November 17, immediately Sri Krishna Committee was set up. A white paper on data protection framework was released for India. In July 18, Sri Krishna Committee submitted the draft bill to the Ministry of Electronic and Information Technology for discussion. The Personal Data Protection Bill was introduced then in 2019. In 2019, again, it was thought, look, this is getting a little complicated. The bill is very comprehensive. Let's come out with a more simpler bill, which is more sort of implementation friendly. And Supratim will highlight on some of the issues. So came in November 1822, a draft digital personal data protection bill was released for public discussion. And in August of 22, this bill was introduced in Parliament and has become an act. The rules are yet to be framed, but people have started taking corrective actions, because this does not only require implementation from a legal perspective, but the systems have to be integrated, the systems have to be brought in line to make it more cohesive. And I leave the floor now to Shukratin to not only talk about the journey so far, but the legislation per se, because he's lived with some of the events which has transpired from more so from July 17 onwards. Over to you, Shukratin.
Thank you so much, Anand. It's really a privilege and an honor to be presenting before all of you. Thank you for your collective time. I'll not spend too much time here. Let's just quickly jump on to the core aspects of this particular presentation, which is knowing more about it and how does it impact you. Feel free to put in your questions. We'll be happy to take them towards the end or even offline. So let's first understand some of these definitions. Okay, why the idea is not to throw a book at you, but just to understand what are the critical pillars that are relevant for the purposes of this discussion. One is the definition of personal data. And why is this important is because the entire law is revolving around personal data, okay, like GDPR and all. So definition is fairly simple, which is any data about an individual who's identifiable by or in relation to such data. The next important definition is data fiduciary. And why is because in the value chain of the medical space, you will have different players wearing different hats. Okay. Sometimes people think that a person who's collecting the data is a data controller. That may or may not be true. Uh, why? Let's understand this. The definition of data fiduciary, who's called data controller internationally in other laws, is any person who alone or in conjunction with other person determines the purpose and means of processing of personal data. Just remember one thing, these are the two most critical words, purpose and means. Okay. So there may be a guy who's gone for collection of blood samples, but someone else has dictated, some other entity has dictated them to go and do that activity. So the purpose and means of processing that personal data has been dictated by someone else. Some other entity has sent an individual to do a collection of a sample, which could be a pathology related sample. So just as an example, data processor is any person who processes the personal data on behalf of data fiduciary. So in my classic example, uh, that particular collector of that blood sample was the processor, because that person did not really apply his mind as to the purpose and means of processing of personal data. The person has really just followed the diktat of the data fiduciary or the data controller, as it is called internationally. Also, why this is important to understand is because the law has entire liability or responsibility on the data fiduciary. So if you are that hospital, for example, who's engaging some of these players as processors, you will have to ensure that adequate insulation is there in the contract with the data processor. And in Indian context, it is more complex, because if you simply write, I will have an indemnity against you, it may not work, because the data fiduciary may get slapped with a penalty of say 250 crore rupees. But at the back end, if they're trying to simply get that money through an indemnity provision from the process, it might take forever. So you have to be smart about curating it, understand what kind of processor do you have. If it's a, say, a 4-member team which is doing your payroll processing, you have to understand that what are the insulations you need to tell them to have. Do they need an insurance cover? Do they need to have a bank guarantee, etc., etc.? A number of processes are possible, but you have to think through those arrangements. Next is data principal, who's basically the individual around whom this entire law revolves. So data principal is the individual to whom the personal data relates. And where such individual is a child, it includes the parents and lawful guardian of the child. And if the person with disability, then it includes a lawful guardian acting on her behalf. Okay. Data processing, I'm not getting into this because the definition is globally well known, and it is anything that you do with personal data. Okay. Whether it is collection, storage, sharing, disclosure, whatever happens, it is all coming under the definition of processing. Now, what are the key highlights or the top 8 things that you need to know about this law? This law covers only digital personal data. If there is something written in a piece of paper which is containing personal data, it is normally outside the purview of the law. But if you scan the document and put it in your computer system or network, then it comes within the purview of this law. Next is there is no non-personal data coverage. Also, there is no categorization of normal personal data, sensitive personal data, or critical personal data. This is also a difference between this law and GDPR and other such laws. We have a flat structure. All data, personal data, needs to be protected in an equivalent manner. Point number 4 is transfer of personal data to other jurisdictions. Thankfully, right now we have a situation where it has been almost given a clean leeway to be transacted with any jurisdiction. So data can freely flow across the border. But there are 2 catches. One is that the government will come out with a negative list of jurisdictions. Transacting QA those jurisdictions could be embargoed. Number 1. Number 2, if there is a stricter law, then that will prevail over this general leeway. Simple example could be Reserve Bank of India does not want that our payment systems related data should be housed outside. That's a stricter law that will still prevail over this general leeway. Point number 5, I already told you all obligation is on data controller or data fiduciary as it is called in this law, and nothing is there on the data processor. So if you are a company, again, engaging a data processor, then you have to ensure that you have adequate insulation through contracts. If you are a processor also, look at your contracts very carefully. You should not be taking more obligation than you should have ordinarily taken under the commercial arrangement that you are entering into. A simple example could be, again, a company and a payroll service provider. First of every month, the company says that you give this salary respectively to these employees. Now that payroll service provider is not applying their mind to find out what has to be done, the purpose and means of processing the data. So that payroll guy would be a processor, and you would be, which is the company, would be the data fiduciary. And the entire liability or responsibility under this law resides on the fiduciary. If they want to insulate themselves at the back end to QA that processor, then they will have to contractually agree on that. Next point is children's personal data. There is bar on targeted advertisement and tracking and monitoring of children. And you are all aware the age of consent is pretty high in India. It is 18 years. Under other laws like, say, GDPR, etc., it's 16 years. As per the member states, it can go below up to 13 years. Okay. So if you're handling children's personal data, verifiable parental consent has to be taken. Point number 7 is data breach reporting. There is no materiality or risk-based threshold which has been prescribed. And if there is a personal data breach which occurs, you have to notify it to the the individuals and also to the data protection board. Point number 8, why this has become a board level discussion is because of very, very high penalties. Okay, it can go up to rupees 250 crore or more, depending on what kind of offense it is. This is the schedule of the penalty. But the good part is that there is no imprisonment provision. Okay, also, the individual does not get any compensation out of this. All this money goes to the government kitty. You have to also remember that there is some duties on cast on the individuals as well. If you see the third last point, non-compliance with duties of data principals, who's the individual, suppose they start a false grievance process or give fake information about themselves, then there could be a penalty of up to rupees 10,000 on them. The amount is small, but at least there is some obligation on individuals as well, which is not seen in most international laws, by the way. Next important thing is, what is the applicability of this law? It is applicable to, in the Indian context, when it is within processing is taking place within India, it is applicable to all personal data that is collected in digital form. Even if it is collected in non-digital form but later digitized, this will apply. If you are a player outside India and you're trying to provide goods or services to people within India, it is even then it is applicable. There are certain exceptions which are there. For example, if it is for personal or domestic purposes. Example, you and your home computer, you prepare a list of people who will come for your birthday. Now that's your personal or domestic purpose that does not come within this law. Also, if the individual himself or herself goes and puts the data out in the public domain, it is then not covered. Or if there is any entity which is required under law to put out that data, then that is also outside the purview of this law. Notice and consent, I think, are two critical aspects of this law. Both will fundamentally change for India, because till date we have not been writing our notices and consent language in this manner. So what are the four important things you need to include in your notice? We were talking about implementation. What do we need to do? The minister on 20th September, there was this first dialogue on Digital Data Protection Act. The few things which came out very clearly is that some of these low hanging fruits, for example, change of notice and consent, etc., that may not be given too much time. Other things which might take more time, for example, verifiable parental consent to be taken, which requires engineering changes to be carried out at the back end, the government may be more keen to give you more time to prepare for that. So if you look at this notice and consent that we're going to talk about right now, it is the expectation of the government that people will try to look into this and make changes to their notices and consent as soon as possible. Okay. So let's watch out for those notifications that come out on enforcement of law, but these are things which are low hanging and can start working. What are the four things you must write in the notice? What are the personal data that is being collected, the purpose of collection, the manner of exercising right to withdraw consent and right to grievance redressal, and the manner of complaining to the data protection board. Now, interestingly, the law wants you to put this in English and also provide an option to the individual to access this notice and consent related aspects in 8 scheduled constitution languages. So, which is 22 languages, basically. 8 schedule of the Indian constitution contains 22 languages. So you have to kind of make provisions for that. Many of the players have started looking for translators, technological measures, and also some of them are sort of taking a call as to which all languages they think they should first get sort of translated into, and which all they will continue to look into, because they may not be very relevant, but they're definitely intending to be compliant. So this is a very interesting area which government seems to be very keen on providing of this notice and consent in 22 languages. Uh, One other important thing is on legacy personal data. A lot of us have, a lot of old data. So this law does not want you to send a request for reconsent, which is a good thing, because you could, when GDPR came into effect, we suppose if 2 lakh people were sent requests for reconsent, not even 20 people reverted. So the entire database got wasted. What this law wants you to do is send notices, and you can send the notice through blast emails, through in-app notifications, etc. And what you should mention in that notice is what is mentioned here. Okay. Consent, like I told you, will fundamentally change. It has to be specific, informed, unconditional, unambiguous, with clear affirmative action, and limited for specified purpose. Other things that are to be mentioned are given in this slide. I'm not going through them, but there is one example which is given in this law which is very critical to know. If there is a telemedicine app, and the telemedicine app asks for your consent for processing personal data for telemedicine purposes, and also asks for your access to entire phone book, that second part of the consent, which is access to your entire phone book, is basically no consent. So it is a very unique thing which is being brought out in this law. There could be a possibility of auto expunging of consent even when the consent was given. So today you might be thinking that I have taken an all encompassing broad brushed consent from the data subject. But tomorrow, the Data Protection Board might sit in judgment and decide that whether this particular purpose was actually correlatable to what is being offered as a service. So, an important element is how you craft your purpose. What are you writing in your consent related language? A novel concept has been brought in, which is of consent manager. I'm not getting into technicalities. Let me explain to you in very laymanish because this is what we lived during the Justice Sri Krishna consultation, which was happening. Um, and we realized that in a country like India, consent is absolutely useless. Okay. The reason is that there is huge illiterate population. People are speaking varied languages. Okay. Even the most educated people are not seeing what they are agreeing to. They're just pressing I agree and I accept and just moving ahead with the consent. So what is that solution that is possible in order to cure this issue? Okay. One of this solution which was thought of is this consent manager. What if we have a service provider of sorts in between, and the individual approaches that service provider and says that, listen, I am okay to give my consent for ABC, but I am not okay to give my consent for XYZ. And that consent manager takes care of this particular diktat given by the individual. So that is, in a very, very crude sense, what the consent manager is. It is to act as a single point of contact to enable the data principal to give, manage, review, and withdraw consent. It is supposed to be registered with the Data Protection Board of India and to follow whatever diktat the particular board is stating. Now, apart from consent, there are some other grounds of processing. Like consent is a ground of processing, you need other grounds also, right? For example, point number 3 here, which is medical emergency. If medical emergency has occurred and you are thinking that I will take consent from that individual, it might be quite fruitless exercise. So that is allowed under law. Medical emergency is permitted. That time you need not really take consent from the individual or show notice, etc. Similarly, there are other grounds in the context of employment. In the medical space also, it's very important, like in many other sectors. In an employer-employee relationship, many a times we see that when we do internal investigation, you have to technically take the sign of that individual whose computer or laptop you will be seeing, because that guy would have kept some sensitive personal data there. And as per the letter of the law, you are supposed to take that consent unless you've taken it before. So in order to solve for that, we requested the government that we should have employment also as a ground of processing. And now if you see now point number 2 here, that's a ground of processing. There are many such. I think we can go on and on, but time is less, so we'll keep it snappy. Next is data principal rights. So individuals can come knocking at your door, whether it is your employees, your customers, vendors, whoever has given you personal data can come knocking at your door and say, listen, I want to access my information. I want to exercise my right of grievance redressal, right of correction and erasure, right to nominate someone in case of death or incapacity of the individual, etc. And you have to take care of it. Next is data breach notification. If you look at point number 1, the definition is fairly broad and vague. There is no criteria such as the GDPR on the basis of harm. So if any personal data breach occurs, then you'll have to basically go ahead and notify to the Data Protection Board and also to the individuals. There is another category of data fiduciary, which is called significant data fiduciary. And how do you determine that you will become a significant data fiduciary? Right now, only thumb rules have been given, and that is, it will be determined later on basis the volume and sensitivity of personal data process, risk of rights of data principle, potential impact on sovereignty integrity of India, risk of risk to electoral democracy, security of state, public order, etc. If you become a significant data fiduciary, there is a possibility that some players from medical space may become significant data fiduciaries. In that case, what are the additional obligations which might come? It is, they'll have to appoint a data protection officer who's based in India, to appoint independent data auditor, and undertake data protection impact assessment and periodic audits. There are certain exemptions under this law. I think I'll not go through all of them, but one part is very important, which Anand will cover in the last part of this presentation, which is on mergers and acquisitions. The only exemption which has been given is that if there is a scheme of compromise or arrangement, through an NCLT or a code-driven process, it is only then that this particular law would largely not be applicable. So you need not go and take consent from individuals. But otherwise, if it's a private merger or acquisition, say a business transfer which is happening where a database is moving from entity A to entity B, or hospital records are moving from entity A to entity B, then technically speaking, you have to take consent from each of those individuals. If it is employees or people who are moving, then their consent as well in order to move their data. What is the grievance redressal process? Firstly, you have to go to the company itself, which is the data fiduciary. Then the next level of appeal can lie to the Data Protection Board of India. Then it can go to TDSAT, which is the Telecom Dispute Settlement and Appellate Tribunal, and then the Supreme Court. There is some avenue for mediation also, and furnishing of voluntary undertaking in order to close out issues which need not be then, going up to the court. Implementation. Many have asked this question that, what do we do now at this stage, right? Basically, there are three phases. Okay. Phase number one is training and sensitization. Right now, what we are doing right now is one of them. You need to ensure that your people, right up to the last person on the floor, is well educated on this law. The first, and see, again, one size does not fit all, right? So firstly, you have to see the first line item. If you see, it's a presentation to the board or leadership. It can be a 45 minutes odd presentation just to take the buy-in of that particular the leadership. Then you can have a 1 to 2 hour session for the mid management who will oversee the entire privacy program. And the third one is a master class, which could be a day long session or a half day session for the people who will dot the I's and cross the T's. For example, legal team, compliance team, privacy team, etc. Phase two is the gap analysis. Because you are already in a sector which is somewhat regulated, you would have things in place, or you would have some aspects which are in place. So therefore, the idea is to see where you are and where do you need to reach. So how do you do that? Firstly, interview the relevant stakeholders. Then we have been preparing questionnaires and taking inputs, and then preparing gap analysis reports. Then comes the last phase, which is the third, implementation, which is effecting of the recommendation. There is discussion on implementation, then step plan prepared, and then assistance with the implementation. For example, changes required to privacy notice or consent or agreements and things like those. Okay. So with that, I come to an end. I will hand this over to Anand to quickly take you through the data privacy and M&A aspects. Over to you, Anand.
Yeah, thank you, Supratim. That was very elaborate and quite exhaustive. I'm sure members would find this interesting. Now, coming to the data privacy on the M&A side, look, of late, the healthcare sector, be it health hospitals, be it diagnostics, all are undergoing a lot of churn. And we see a lot of M&A activities. When I say M&A, we mean joint ventures, we mean private equity investments, we mean, takeovers, mergers, amalgamation, everything, every aspect now would require a careful consideration from a data privacy perspective. As I mentioned in my earlier part of the presentation, look, this has become very important, and from 2011, people have been very focused. And I think with this new law coming in, with the new rules which will be framed, which will come out shortly, I think there'll be more sort of a lot more focused on this aspect in a due diligence. So let me tell you that, look, from typically what in an M&A transaction one would look at. Let's look at it from a seller's perspective. In a typical seller's perspective, what would one look at for an M&A transaction? First, look, there could be a customer contract, there could be a supplier contract, there could be an employee contract, or there could be other general contracts. Now, everywhere there has to be a check and balance being done to see whether, look, is there any consent required to, further share the data for the purpose of due diligence? Because due diligence is going to be a very important component in any M&A transaction. So first aspect would be to see from a seller's perspective that, look, how, this data can be shared. One of the ways to look at it is, looking at the virtual data room can be set up, the documents can be encrypted. There is another way of looking at it is, look, there is no consent would have been obtained for transferring data. Can an M&A activity wait? The answer is no. Can a due diligence wait? The answer is no. Therefore, the way to do it is to give a sample agreement, because some of the information sitting there of employees which are personal in nature, which could get captured within the data privacy fold, may not be shared. And therefore, you can blank out those information and share a very standard contract of each employees in a particular sector, in a particular category. So that's one way to do it. Then the other way to do it is, look, by sharing this data, if the deal doesn't go through, or if the deal goes through, am I taking a huge sort of a business reputation risk. Will my image get tarnished? So therefore, again, it needs to be checked and seen that, look, whenever these data are being shared, a careful analysis must be made, because otherwise there are huge chances of a litigation and damages, and from the people whose data has been compromised, as one would call it. From a buyer's perspective, what would one really look at? From a buyer's perspective, one would look at, look, what is really the flow of data, both offline and online data which is flowing. Then what is the cross-border data which is involved? For example, if there is a European Union General Data Protection Regulation applicable, then one will have to look at it from a buyer's perspective as well as from a seller's perspective. That, look, what are the things which I need to check to see that, look, when data privacy information, when data is shared, there's going to be no transgression. Again, same issues which a buyer would face, that I'm going to face litigation. My data, when it will be merged, when I'm an acquirer, is going to create a problem. So therefore, these are important aspects for the buyer. Again, you look at the policy of the seller to see what measures have been taken. You will also look at what are the records which are there, which suggest that, look, has there been any breach? Has there been any audit been conducted? Is there a data grievance officer appointed? If there are issues which cannot be handled, then an M&A transaction cannot wait. Therefore, you could look at doing a transition services agreement between the buyers and the sellers. Here, the one cryptic note I want to share, that, look, no M&A deal is going to get stopped because of what you call as a data privacy issue. But once the transaction is completed and there is a data breach or some transgression noted, there could be a value erosion, there could be a reputational damage, and this is what is necessary in a diligence exercise. Now, coming to some very basic queries, because we will allow the room for next speakers. What would really one look at? What I'd look at: sample consent letters, agreements, emails which being used. What are the processor and other third-party assessments? As I said, you need a data protection officer. And what are the process involved in the whole exercise? For example, how is data collected, how is data stored, and how is data processed, and who's processing the data? And again, when the data is processed, it's being handed over to an agency. It's being done internally. The person who's the holder of the data as a fiduciary has the same responsibility as that of an owner, and he should take same precautions if he passes on for the purposes of for processing. So therefore, what kind of agreements are being executed between parties is going to be relevant. So these are some of the important issues around privacy, and I'm not getting into details. You would have surely seen in the slide some of the issues which would have flagged out. Coming to the next part is, what are the issues involved in a typical M&A transaction in a nutshell? One was to clearly see what is the structure. And here, as Supratim pointed out, that, look, in a typical M&A transaction, data privacy would be a concern. But if there is a merger through a court process or a tribunal, then there is an exemption. Therefore, you may not have to comply. But rest all, be it business transfer, be it asset purchase, be it in joint venture, be it an acquisition, in one form or the other, we'll have to look at the issues which are covering and involving data, and one has to be careful how data would be transferred and how next steps, how the acquirer or the new organization is going to look at the data. Again, for this purpose, I will look at only three critical parts here because we've covered most of them. Is when you're doing the definitive documents, you have to be careful that, look, you're asking for the right reps and warranties. You are asking for correct indemnities, the specific indemnities, which if you have seen that there's a transgression or there's a breach, because you would always look at a situation like whether there have been cybersecurity fraud, etc. And basis that, you're going to ask for specific indemnities or general indemnities. Again, you'll have to draft proper documents to see that you are defining proper terms, you're defining condition precedents, and all other aspects in a very careful manner. Looking at the sector which we are, there's the healthcare sector, we'll have to evaluate and see, who are coming within the definition of the controller, who's coming within the definition of fiduciary, and then accordingly shape the agreements. So these are some of the very finer points for an M&A transaction. This, of course, gets subsumed in a wider, data privacy discussion, which Supratim had pointed out in a few minutes. I think I'm done with this part on M&A. I think we let our co-panelists take over, and over to you, Om, for further discussion on this aspect.
Okay. Shall I continue now?
Yeah, thanks, Anand. Sorry, I got caught up in something. So I think that was very insightful, sort of a download on the Act. So I think now we move to the second session, which is the solutioning side of it. So Saurabh, why don't you take us through some of the, while some bit of it is already covered in this, you can probably throw a little more light on this area. After that, we'll open it for Q&A. Now, I do see that there are some questions already put in the chat box. If some of you can see it while talking and start addressing it, it also may be helpful. Yeah, over to you, Saurabh.
Sure. Give me a minute. Okay, so thank you very much, Dr. Rom, for the introduction. I think good afternoon, everyone, and thank you for your time. Joining time for this important webinar session on Digital Personal Data Protection Act and its implication on healthcare organizations. So, healthcare organization, handles some of the most sensitive personal information like patient medical records, treatment plans, insurance details, and more. So it is, absolutely it's absolutely critical that this data should be, properly secured and protected from the unauthorized access. Even in the Dpdpa Act also, they have established a clear obligation for how personal and sensitive data must be managed. And it is, our co-panelists have rightly mentioned that it is the data fiduciary responsibility to ensure the safeguarding of the data which they would be collecting from the data principals. And I think they have already mentioned there are like stiff penalties for non-compliance and if any data breach incident happens. So in this webinar, I will try my best to share the best practices for data protection and managing breaches effectively, which can actually help in terms of protecting PAI and sensitive data to avoid such penalties. So I think to begin, I would like to present some facts on the data breaches, which happened globally and the cost involved around it. So as per, the IBM data breach cost report 2023, it shows that the healthcare industry suffered most data breaches than any other sector with massive costs involved. I think the figures are there in front of you. I'm sure you should be able to see it. So this research was conducted, independently by Ponemon Institute, US, and this report was published and accounted by IBM. And under these studies, approximately 553 organizations impacted by data breaches, and they actually collected the data during the period March 2022 to March 2023. Also, the breaches study took place approximately, not approximately, but yes, 16 countries, including India, with 17 different industries. So I think just to show this breaches cost healthcare companies, average cost is very, very high. And it clearly shows that healthcare data breaches approximately $10 million. And this figure is approximately 80% higher as compared to breaches in other industries. So now, since you have the cost, involved, I think let's understand in the next slide why the cyber security and data protection process driven approach should be priority and needed in this healthcare industry. So I think the cybersecurity, that's why we have a title is the crucial role of strong cybersecurity in safeguarding sensitive information. So, cybersecurity is more than ever to protect sensitive data, whether, it's like financial records, healthcare information, or proprietary business data. So strong and robust measures are essentials to safeguard, what matter most. So as shown in the slide, there are like few key cyber threats which are on rising track. I have provided some data also in comparison data for the last couple of years. So I mean, everyone knows cyber attacks. We talk about a lot about these cyber attacks. So I mean, these are like becoming very increasingly sophisticated, and hackers even develop more advanced techniques and tools. So like we are as an end user, as a company, we are also upgrading ourselves. I think the same rule applies on the hackers also, and they are crafting highly targeted phishing emails, exploiting zero-day vulnerabilities, using polymorphic malware to evade detection, and leveraging automation to carry out attacks more quickly. So means that defending against these persistent and evolving threats requires like vigilance and a proactive cyber security strategy, which I would try to cover briefly later in this presentation. I think the next point is the hacking tools. Considering now we have AI in our in life, and with help of AI driven tools, cyber criminals today have access to sophisticated hacking tools that are widely and cheaply available on the internet, for example dark web. So I mean, these attack technology allows even low skilled actors to carry out advanced, persistent, and defending against these attacks. I mean, it requires a multi-layer security approach and advanced threat detection capability. But the good news is that we have such tools available now, which are primarily driven by AI and machine learning, which are like far more effective even in a real-time mode. And rising cost of cybersecurity means, as we have shown in the cost of the data breaches, the financial and the reputational damages from cybersecurity breaches is rising every year. You can see the data. Means a single breach incident can cost millions in stolen funds. I mean, it's also like replicate to other things like lost business and legal fallouts and recovery efforts. So means as threat increases, I think the strong and effective cybersecurity is essential to manage risk in today's I would say a digitized world. I think the very important point is the board level involvement of board level in terms of meeting the compliance issues. So cybersecurity has become a critical concern that board directors and CXO can no longer afford to ignore. Means like high profile breaches at major companies have made it very clear that the cyber risk compliance, I mean, it's not like just a like an IT baby now. So I think to exercise proper governance, board must actively involve in the overseas cyber strategy instead of just handing over these department or these things to IT. So means I'm sure, I think if any companies, any people would be following the IS 27001 on HIPAA, I'm sure the steering committee and the CXO and the board level would be playing a like key role in terms of managing the like healthcare companies and I mean other companies also to managing and these cybersecurity and data leakage related issues. I mean, I think another big important point is the cybercrime big business. So it means cybercrime is evolved into a highly professionalized and lucrative criminal enterprise. Like vast underground market like dark web enable an interconnected web of cyber criminals to buy and sell hack data. I think we are reading news on like a daily basis that this kind of data is available on dark web and all this stuff. So I think this is some of the threats. Through in order to manage those threats, we should actually have a strong cyber security process and policies in place. Another, I think the importance of advanced monitoring, especially using of AI and ML. I think some of the data I have tried to shown in this slide, but advanced monitoring leverage AI and machine learning play a key role and has become a mission critical for detecting and prevention cyber threats. So I mean, the volume of security data and the logs, I would say, which have been created and generating by servers and other network equipments means it is not possible for a human being to review it even on a real time basis. So that's where the AI algorithm will come in picture, and they can quickly analyze massive data set to identify suspicious pattern indicative of, let's say, any malware attack, suspicious user behavior, insider misuse, or sophisticated intrusions. So means there are like multiple tools which are available. I'll just name some a couple of example, like adaptive access, contextual access, and privileged access management. These are some of the tools which actually work on an AI driven model, and they are highly effective in terms of like stopping any data breaches. Nowadays there are like another tools, I would say, which actually work on a contextual based monitorings. So for example, who actually created that document, what kind of content is there in the document, and those tools actually label and classify the document accordingly automatically without any human interventions. So someone and they actually don't collect the actual data. These are like SaaS based tools. They don't collect the actual data of the document. They simply work, they just collect the metadata of the document and take the action accordingly. So for example, you created any any sensitive document, and someone is trying to send the document through WhatsApp, and on a personal Dropbox. So I think these kind of AI driven tools would be highly effective in terms of stopping those data breaches. So I mean, that is one of the example which I'm sure very effective in terms of safeguarding and protecting these data breaches. The next point is the responding to cybersecurity incidents in systematic and organized approach. So means the like responding effectively to cybersecurity incidents, is definitely very much need of the hour. Chaotic or ad hoc responses damages and lead to costly mistakes. So I will strongly suggest that if we have a like incident response plan, which should lay out like roles and responsibilities, communication protocols, and technical steps. Means I'm sure once we start following this HIPAA and ISO 27000 guidelines, they incident management policy would take care of all these things. So I think the incident response team needs defined procedures for containment, recovery, and reviews, and even post incident analysis, identify gaps to improve future responses. So I think draft and incident management policy along with business continuity plan will cover all these aspects, and follow a policy driven approach would play a key role to manage and any cyber attacks or data breach incidents effectively, which is also an important part of the DPDP bill as well. This is the leveraging compliance and, for example, ISO 27001 and HIPAA. So adopting these cybersecurity compliances framework like ISO and 27001 provides multi-phase benefits beyond just meeting legal obligations, and the standards codify best practices that reduces risk in a systematic manner. So that means once you go for a framework like ISO 27001, definitely it has to be a process driven approach, because the company would be having a document, for example, what is the process and policies for patch management, vulnerability, how to secure your endpoints, who should actually get an access on the server where the sensitive data is hosting, and I think privilege access management, and what kind of a mechanism do you have so that the person actually who is working on the server should not be able to copy the data on their personal laptop or desktop, or over cloud. So these kind of tools are very much needed, especially the kind of data breaches are happening, and I think that is the need of the hour. I think these are some of the best practices I would say is very much needed in terms of stopping the data breaches and to meet this DPDP Act compliance. I think that's all I have as of now from a solution perspective. But yes, I would be more than happy to answer questions, I think, in the interest of saving time.
Thank you, Saurabh, and Khetan's team. I think it was very comprehensive. And as you all mentioned, the first step is to get sensitized. I'm sure this group is fairly well sensitized now. Uh, if the time permits, I guess we have sufficient time. We can go to Q&A. There are some questions in the chat box, but I have one or two questions. Maybe let me kick that off. Um this healthcare is, I'm not sure whether you're fully aware, it's highly sort of a fragmented sector. And secondly, the journey of data principle, which I guess is a patient, actually the relationship of that is not with one organization. It's actually with multiple stakeholders. It could be diagnostics, it could be a doctor in an individual capacity, it could be doctor in an institutional capacity, it could be an institution itself. And the data is actually moving along with the patient to lots of people. So when I sit down and I think go by definition of yours, everybody can say that they are not the data fiduciary, but they are the data processor. How do you really decide who is the fiduciary, who is the processor? Because everybody has parts of the information, but everybody disowns that, no, they are not the fiduciary.
Right. I think very good question, sir. Let me take a very off the industry example. When we are traveling, the travel agent and the airline both have our information. It's the same set of information, right?
Right,
Both are determining the purpose and means as to what has to be done with the data in their own capacity. Okay.
right,
The good part about some of the international laws is that they are creating an avenue for a joint data fiduciary. Okay. Two people are deciding what has to be done with the data. Okay. The processor element is relatively simpler because they are not determining anything whatsoever in the context of what has to be done with the data, how it is to be done with the data. The problem in our law is that there is no specific calling out of joint data fiduciary. So what you have to do in this whole ecosystem that you just mentioned, the chain of organizations which will have the data, is to determine amongst themselves who is determining what about which part of the personal information of the patient. That's number one. So that guardrail, when it is created clearly, would be helpful. If there is any dispute between them. B, if there is any dispute qua a data subject or a patient, and the data protection board, etc., calls for this particular understanding of between the two entities. The second thing, which is an outward looking aspect, that to the patient, are you clear that which part of the data is getting housed or transitioned through whom? Okay. So that in a bad day, in case it's required, then you will be able to pinpoint and say that, yes, we are joint data fiduciaries. However, I am responsible for this part of the data, and this other entity is responsible for the second part of the data. I think it will be a bit of a cumbersome exercise for some time till things get more ironed out in the Indian ecosystem. But that's the only way to go about, given the construct of the law.
so let's take an example that you took. I think it's a very good example of airlines and travel agent. So in international law, both are joint fiduciary. Is that what it is?
Yes, that's right.
And in Indian law is not is
There is no
silent.
specific segregation. We just have two categories, which is in this context, which is a data fiduciary and a data processor. So in case there are two people who are wearing that hat, then you will have to kind of create that arrangement between the two people, between the two entities, that these two people are the joint data fiduciaries.
Okay. The second question that I have is, let's take example of a diagnostic sector. I get samples from hospitals, but I actually, if hospital can mask the identity of the patient, there is no way I would know who the patient is, right? I just get a sample. I get few data points like age and gender of that sample, and the test needs to be conducted.
Right.
Now, if I don't know the name of the patient, technically speaking, I don't have any identifiable information, right?
Right. So that's an excellent question. And if you look at it, this law is pertaining to personal data only. Okay. There is no mention of either pseudonymization, which is turning, say, Mr. Om as ABC and Shupratim as XYZ, okay, and then giving it to someone. If it is anonymized, however, one can take a safe call that, listen, this is not even linkable to the natural person. So it's kind of outside the purview of the law. Just amongst this group, there is a possibility that the government may give a threshold for anonymization in future. But in the absence of such a threshold, I think a safe call can be taken that if it is fully anonymized and sent to you for the pathological purposes, for testing purposes, then it is kind of outside the purview of this law, because you do not have the ability to understand who the natural person is. Okay. However,
Right.
to make your question a little more complicated, suppose in the same organization, we just simply pseudonymize the names, like again, Mr. Om is ABC and Supratim is XYZ, and some other organ of mine is handling that pseudonymized data, and I'm very happily stating that I do not fall within the purview of the law. That could be very risky, because within the same ecosystem, someone can put back the pseudonymized formula and understand who the natural person is.
Yeah, that is gaming the system. I don't mean that.
Yeah.
Yeah, I understood that. I don't think I meant that. I basically meant that I actually technically don't need name of the patient.
Yeah.
I'm
No,
I
in your
only
case, I think it's fair. It's quite clean. I was just trying to make it a little more complicated, because some organizations do come up with this
okay,
kind of
okay.
an alternative.
Yeah. Okay, third question that I have. Sorry, I'm probably trying to figure all the question that I'm carrying in my head. I want to ask first. Uh, you are aware about this whole Ayushman Bharat digital mission, right? These guys are issuing Abha IDs. Okay, now if I move to the system where I only take Abha IDs from patients, and I'm actually extracting the information on that Abha ID from, let's say, I presume it will be very similar to like what Aadhaar is, right? And then it comes to me, and my system only knows about Abha ID. It doesn't know anything else. And the patient also are using Abha ID to extract information from my system. Uh, does it mean that we are okay with that sort of format, or or does it put us in some kind of risk zone that I still need consent from the patient? Because I am told Abha ID itself is a very consented process. There are a lot of consents that are required there.
Right. So I have to go through. Honestly, I have not gone through the exact consent mechanism that is followed. And talking about Aadhaar, I'll tell you, it's a bit scarred. You are aware when the Supreme Court has looked into
Sorry,
it.
I'm not talking about Aadhaar. I'm talking about
No,
Abha
no, I
ID, which
understood. I
is
understood. I'm just trying to draw a parallel to make you
okay.
understand that how it could be looked at. So I think if it is a consented process, we will have to see that what kind of consent was taken in order for you to be handling the data. And the
Okay.
second thing is that when it is, in an ID only that you are getting, and not the actual individual's data, I think we go back to the same deliberation that we were having in the previous question, that is there any mechanism for you to find out who the natural person is? If not,
Okay.
then you are outside. If yes, then you are
If
within.
yes, then you have a challenge. Yeah. Okay. Got it. I think that's very clear. So those are two or three questions from my side. Let me just go back to the Q&A part, right? Okay. The question is, who onboards the consent manager? Is it DP or someone else? I think that's a question which is there. That's the
Yeah.
way I've understood it. Yeah.
Yeah. So I think till now, the way the law is looking at it is that it is a right of the individual to approach uh, a consent manager. Okay. Now, whether it will be an independent body or every organization will have to make arrangement for it is yet to be seen, because the government is also still mulling over it. So my request would be to wait out on this. But if you ask for a thumb rule, it is the individual's right to really have a consent manager.
Okay.
Yeah.
The second question is, since no exemption on BTA, ATS, etc., does notice work? Sorry, I don't think I understood this question.
Yeah. So let me break down the question for everyone's understanding and give the answer also. So so this is the example that I was giving. So what happens in a business transfer arrangement or an asset purchase agreement is actually a data set. Say a hospital is getting sold, then the entire uh, client patient database will have to move from hospital A to hospital B, okay, or entity A to entity B. Now, if you look at it, all the people, they would have given consent to hospital A. Suddenly, they're getting moved to hospital B. Now, if this is happening pursuant to a scheme of arrangement, then it gets a rubber stamp under this law that you need not go and take consent. But otherwise, then you should have consent. The question here is, will notice suffice? Notice and consent are two different things. To my mind, notice here will not suffice. It has to be a consent driven process, unfortunately, or a call has to be taken that whether an entity would like to go ahead with the transaction without taking a prior consent, which could be risky as this law comes into play, especially. But yeah, notice certainly is not the only requirement. Consent has to be there.
Oh, so that would mean M&A are getting complex, right?
Yes.
Okay, got it. Other question that I can see is, what are the protections available on employees' personal data?
Right. So I think the difference, so firstly, all aspects which are applicable for personal data under this law per se is fully applicable to employment related aspects also. But there is one exemption which has been called out, which is employment as a ground of processing. So what this law says is, just like consent is a ground of processing, for employment purposes or for safeguarding the employer from loss or liability, such as, say, preventing of corporate espionage or confidentiality or trade secret being violated, if it is a protection pursuant to that, intellectual property related safeguards, etc., it's then that you don't need to take consent. The classic example that I gave you is that in today's day and age, if you look at the Information Technology Act and the sensitive personal data rules, technically speaking, you are supposed to go to that individual, that employee, and take the sign off that I'm going to look into your system, unless that sign off has already been taken, if the guy has kept any sensitive personal data in the system. So therefore, this aspect, this particular new ground of processing, which is employment as a ground of processing, will help you to ensure that you don't need this kind of consent from the employee. Employment as a ground of processing will help you to process the data towards.
Sorry, I got some call came. The next question is, do we have secured messaging standard like SWIFT in healthcare recognized by law?
Saurabh, you want to take that?
Sorry, can you please repeat the question?
Do we have secured messaging standard like SWIFT in healthcare recognized by law? I think the SWIFT is like in banking sector, you have something like that. Is there something like that?
I'm not aware of any.
Yeah, I think in DPDP Act, they have not specifically mentioned, what kind of security mechanism we should have. Either they have just mentioned it that, the data fiduciary would be responsible for safeguarding of the data. So it is the, data fiduciary responsibility to ensure they should have a, adequate data protection measures in place. And for example, like a strong and complex password policy, and the access management should be on a least basis. Apart from that, there should be a regular audit and review of those access management and general audit by the third party. So I think these are some of the area where, I think that should actually help in terms of protecting these sensitive data. As far as my understanding is concerned, I think there is no framework which we have defined in the DPDP Act.
Yeah, okay. The next question is, how do you use machine learning in depth? I guess this is a much broader question, so maybe we'll skip this. Maybe offline, that person can reach out to you. Okay, the next question is, healthcare sector has large number of one-doctor clinics, small hospitals and diagnostic labs, home healthcare who cannot afford to engage senior advocates or buy expensive IT security equipments or software, etc. Please advise top 5 inexpensive steps that such organizations must take to comply with DPDP Act.
My honest and answer would be, I think they should look for SaaS-based tools. For example, for the email, either M365 or G Suite. I think that would suffice the preliminary and the basic requirement of the DPDP Act, whether email is secured. And as they grow, actually they can also add on add on another security features, for example, classification of the documents. So my short answer would be, I think they should go for a SaaS-based solution, for example, M365 and G Suite. And I think that would actually cover most of their compliance and security related requirements. And that would be, on pay on use basis. So it would not be very expensive. They don't need to spend upfront cost on any, IT hardware or infrastructure.
Okay, great. So the next question is, how do we determine if EMR, I guess EMR is electronic medical record, is a data processor or a fiduciary?
No, I think maybe Sasmita, if you want to clarify that this EMR may be something different, one of the players and not electronic medical records. We can move on to the next question.
Yeah, we can move on to the next question. Yes. Diagnostics has two verticals, technical and business, I presume technical and service. Can the business vertical have access to patient data and test results? Is it breach of data security? I don't think they're part of one
No.
organization, right? They're
Yeah.
not
So,
split
so,
like that.
so, yeah, I think the way to look at it is that what is the purpose that you mentioned when you were onboarding the patient and you're having that, information from them. Ensure that you properly articulate it so that it can be used by the business vertical as well. Uh, of course, you cannot be cowboyish about it, but in a limited sense, within the same umbrella, it should be used.
Right, right. Okay. Can we send promotional emails, messages of our partner affiliates company to the consumers? I
It's the
think this
same
is a very
answer.
good question.
Yeah, it's the same answer, but again, we have to just keep that in mind that when we are talking about, see, purpose limitation is a very big thing, both in international law and in domestic law as well, as it will evolve now. So you have to see that what is necessary for the purpose is articulated very properly. And if you've taken appropriate consent for such mailers, then it should be doable. I don't think that this law tries to completely stop cross-selling, upselling, and all of those. That's still possible. One other element I would like to sort of bring in here is that because of our interactions with the minister and the ministry, it came out in multiple conversations that whilst it is important to protect personal data, but it is also the intent of the government that innovation, entrepreneurship, and ease of doing business should not really suffer. So we believe that they would try to take care of it to the extent possible and not really stop business altogether. So this cross-selling aspect is quite common. It has to be done properly by taking appropriate consent, etc. Okay.
Yeah. The next question is, what can we? I think it's a probably similar question. How do we secure sending of promotional messages, call to our affiliate partners without breaching any provision? What can we write in our consent which will allow us to call, message, email our database for existing products and future products?
Yeah, I think we've already kind of given an overview of this from a overarching answer perspective. Very happy to take anything specific offline.
Okay, then there are some kudos also coming in. Excellent session, which is Siddharth Bhattacharya. Great. Okay, next is under notice of consent, we are to inform data principal the manner of making complaint to the board. As no guidelines are provided, how should we achieve this?
Yeah. So basically, right now, it is not that you'll be able to dot the I's and cross the T's completely. The idea should be to understand that which all are the aspects that you need to target first. Like I told you, notice, consent, contractual provisions, etc. You need to understand that these are the things that we will amend. Once the rules come into effect, you will actually have more granular details set out there. That is what you will have to, at that time you'll have to adopt the relevant language and finalize this documentation.
Okay, now there are a lot of overlapping questions, so probably I'll switch to some common themes that are emerging rather than picking each question. I think there are some questions revolving around employment. I think we've already addressed that. There are some questions revolving around promotions. Those are also addressed that. I think Sasmita has written about electronic medical records. So I presume we left that question halfway. EMR. I don't know whether that question is still visible. Yeah. How do we determine if an EMR is a data processor or fiduciary? So EMR here stands for electronic medical records.
Okay. So Sasmita, I think the way the law is looking at it is basically an organization will either be, say, a data fiduciary or a data processor. But electronic medical record itself, I'm not very sure as to how you would like to categorize that as a processor or a fiduciary. We were thinking that you were talking about one of the players in the ecosystem.
It can be only correlated to the owner of that records, basically. So if the owner of the record is a data processor, then it becomes a data processor. And if the owner of that record is a fiduciary, then it becomes a fiduciary. I'm also trying to speculate and give a response.
Now, again, I think the thumb rule is very clear that if you're determining the purpose and means, then you are a controller, which is a fiduciary. Sorry, you're saying something, but you are.
No, I think as per my understanding, I think the data producer, the data processor, it's a responsibility of the data fiduciaries to have a back-to-back agreement just to ensure. So I think they would be data fiduciary would be liable if something goes wrong, even at the data processor end. So I think that's the
that's correct, Saurabh. The only issue is that this law itself is not putting any direct obligation on the processor. So in the Indian context, especially, the problem is solely on the controller. And that person, that entity has to ensure that they have adequate insulation at the back end.
Yeah.
With the contract.
So I think similar question has been asked again that if data processor has willingly violated the terms of data privacy as protected by Dpdpa, how is data fiduciary protected? I think to my mind, this is a huge gray area in healthcare. I think it can take so much of time till cows come home to decide who's a processor, who is a fiduciary, because you know that on a processor you are getting away with 10,000 rupees, not even 10,000, I believe. 10,000 is for the principal, nothing actually.
There's nothing, zero.
And fiduciary could be 250 crores. So I don't know. This is to me a very complex sort of a arrangement because somebody who sends the agreement first saying that, okay, you are a processor, then, it's like, I think probably this is something as all stakeholders in healthcare will have to probably get clarity. And I have raised this question many times in other forums as well. So I think people are saying we'll come back and understand because the entire value chain is there's so many multiple players and each player actually can be nominated as a fiduciary also. So I think that there are some questions related to that. Let's move to the next one. In public health services delivery, will the respective government authorities be the data fiduciary? I think that's a good question. Even I have this. What is the responsibility of the government in this? Because many healthcare players are required to share data with the government authorities, which are called notifications, let's say for dengue, malaria, even COVID also. And unfortunately, I'm not fully updated on this, but I think in the past I did see that some of these government officials are using Gmail IDs, etc. Not even, and I don't know where the data is actually going because they only give us Gmail IDs. So I just want some clarity on this as to how do we go about handling this.
No, so two things. One is that yes, in their capacity, the government authorities and entities and agencies are also supposed to be data fiduciaries and processors, just the way we are seeing the other commercial players getting categorized. The other relevant thing here is that there are certain exemptions which have been provided for government agencies, bodies, etc. And if there is sharing of information pursuant to any law, there are a number of exemptions which have been given. The thing that we have to be careful about is that sometimes this is not maybe the ask or the request is not pursuant to any law, but just because the person seated in that chair is intending to get that information. So that I think is again a tricky practical situation which we will have to deal with as things evolve. On 20th of September, there was this Digital India dialogue on the Digital Personal Data Protection Act. And at that time, the whole implementation related timeline was discussed. Okay, when is this law coming into effect? And one of the things that the minister said is that there could be a staggered rollout of this law. Staggered, and I was there in the room, so I can tell you like what precisely was the thought process. So the staggering could be of two types. One is dependent on the type of entity. So these agencies that we're talking about, government agencies, state bodies, which are low on digitization, would be given the longest time. So, the Gmails, etc., that you're talking about probably would continue for some time till the commercial, the private players are told to shape up immediately, but government would get the maximum time. The second would be early stage startups, some MSMEs, etc., and maybe some of the hospitals and medical space players could be given that leeway. And last would be all other players who would be required to be compliant as soon as the notifications, whatever the notification state. So that's what we are looking at from a timeline perspective. I thought I'll touch upon that as well.
Yeah, thank you. So I can see a very interesting sort of a comment and maybe a question. Let's say example of testing again, pathology. Somebody comes for a test, I give the report, and I completely destroy the information. I am not holding any information. Is that is that a way to handle this challenge as well? That I'm not in custody of any data. Whatever I had, I gave it to you, and it's all done.
It is a way of handling, and it depends on how you're looking at it from your business perspective. And I'm sure most would not like to look at it but that way. But if you are doing that, then basically ideally you should call it out that once you take the information from us, there is nothing which is left with us. So you are truly following what is the data minimization core concept.
And I think just to add that, maybe, I think data retention period would be very helpful. And what the company policy would decide that, up to what level they are going to store the data, and what would be the data destruction process and policies, just to ensure that, once the purpose is over, they should delete and get rid of the data. So
no, it sounds a little it's hypothetical actually, because certain accreditation requirement, patient data is required because you need to connect past data with the new one. So I don't think it's feasible in our setup, but it's a question which came up when I was asking you whether that's
So one more relevant aspect which I must point out here, that we have made a request to the government that some homework needs to be done at their end as well. Because if you look at the Indian legal ecosystem, our laws hardly come with an end date for storing data. Therefore, out of fear, our organizations continue to store data because you never know which authority, which day will ask for what information, right? So that request we have made, let's see what plays out. Maybe it will take time, but at least we have put it that, if we bring in this end date, which is pursuant to particular laws, I think then we can solve for a lot of those issues.
Right. So the next question is OTP based consent good enough? I presume these are all mechanics to get the consent, right?
Yeah.
Okay, we are required to keep some patient. I think we're pretty much done with the questions here. Maybe one question that I have, which I'm not really sure about this. Let's say now this gene sequencing data, there is humongous data that normally genetic sequences have. And at times, this data actually goes back and forth in terms of analysis, which may go to some jurisdiction outside. But it's still not identifiable, right? You don't know what these data, whose data is this. It's not about telephone number. It's not about name. It's not about address. You have some this data. Now, what I understood that this new law is not categorizing this. It's not a healthcare. It's not sensitive. It's only one information. So should we take this something which is identifiable is the only issue? Otherwise, it is not an issue. Is that correct?
So let me take a few minutes to explain this. So this law is supposed to be a principles-based umbrella legislation for the country. It leaves open scope for sectoral regulators, etc., to play their role under it.
Oh,
So
I see. Okay.
when you look at this law, it is giving you the thumb rule that Okay, this is pertaining to personal data only, and it has not talked about anonymization, etc. So if it is fully, irreversibly scrubbed off from the natural person's identity, one can always say this is no more a personal data. Okay, and therefore it is outside the purview of the law. But let me also tell you, the government is possibly working on some other laws and regulations in the context of anonymization. A, they might give a standard for anonymization, and B, non-personal data, maybe which was at one point in time personal data, those usage, etc., could also be regulated. Digital India Act, which is supposed to replace the Information Technology Act of today and also add things like AI, generative AI, and also some of the new age tech concerns that could bring in some elements in this context in future, not right now.
Okay. So one last question from my end. Now, I talk to people like you. We are discussing as if you are the person responsible to execute this whole thing, but maybe you're not. How do I reach out to authorities at this stage and put my point of view across to them? And there is a dialogue, there is understanding on both sides, appreciation on both sides area. Is there any forum? Is there any place where I need to go? So far, whatever industry has done, it has done basically inputs through FICI and CI, etc.
Yeah.
But is there any place where one can have a little bit of open conversation with the authorities?
You see, two things. One is that we have observed that the authorities are a little more receptive than what they were probably earlier. But again, cogent inputs have to be given in a very specific manner. Whenever they are coming out with these draft legislation, they are opening it up for consultation, inputs, etc. So, to my mind, a very smart and prudent approach could be a two-pronged approach. One is you go through an association, definitely, but also separately try and see that you have a seat in these, some pseudo or sort of closed door conversations which are happening with limited number of people in the room, which can be a very focused sort of discussion on specific points which you guys want to put forth. Okay, a simple example could be on 20th September when some people say that, listen, we need more time for certain implementation of some of these aspects of DPDP Act. The minister clearly said that please immediately then write to us. A, which provision you think you will need more time for? What is the reason that you need that more time? What is the precise extra time that you need? You write to us in that manner. I would ordinarily not like to get theories, and prose and poetry from people. If you are specific and you are sending this across, we'll consider it. So at least this kind of a dual approach, I think, could be helpful.
Well, good. I think that's pretty helpful. We are touching 4 o'clock now. I'm done from my side. I want to thank all of you for your time and valuable insights. They are very useful for our industry. So we are, all of us are very committed to make it happen. But I guess we need some guidance, handholding by people like you as we go along this path. It's definitely forward-looking stuff, and it's required. And let's just see if we all can make it happen together. Thank you very much for your time. I want to hand it over to Chirag for any closing comments.
Thank you.
Chirag?
Yes, sir. Thank you all for the wonderful series. We expected less of question and answers, but yeah, we had a lot to deal with, as well as if people it's not been addressed, you can reach out to me, and I can make the connects, and your questions will be addressed. I would like to thank all of these esteemed speakers, um, Mr. Saurav, Mr. Supratim, Dr. Anand, and our moderator, Dr. Om. And I also like to give a round of applause for our communication partners, Avian. We have Manaswani here, Nisha is here from Avian, and I would like to give all my thanks and regards to all the attendees. And please be in tune. We are planning for another export series that is on patient safety. So please be on tuned. Thank you all.